Chairman of the Guyana Elections Commission.
If it pleases Your Honor, Neil Boston for the third name respondent, the Chief Election Officer.
May it please Your Honors, Kamal Rambrand, associated with Mr. Timothy Jonas for the 4th, 5th, and 6th name respondents.
May it please Your Honors, Mohabir Anil Nandlal and Devendra Kisoon being led by Senior Counsel Douglas Mendez for the respondent Bharat Jagdev.
Good morning, everyone. We have received submissions, and submissions have been coming in up to now, I gather. But we asked Council, as we did yesterday, to highlight the points that they wish the court to note, and then the court will ask for any clarifications that it has.
May it please Your Honors. Good morning, Roysdale Ford.
And then the court will ask for any clarifications that...
It's a very short affidavit, but the paragraph 2 is 3 paragraphs, but the paragraph 2 of the affidavit, we attach a press release from the Guyana Elections Commission dated the 2nd of April 2020 yesterday, in which it indicated in the last paragraph that against this backdrop, a request was made for additional time by Commissioner Gorby for legal guidance to be sought on the matter, and the chairperson acquiesced, and the meeting was adjourned and will commence on the 3rd of April at 10 a.m., where a decision is expected. Earlier in the press release, the decision that they're referring to is a decision to proceed with a recount. The honors will be well aware that when this application was filed and came up before Justice Holder, that interim orders were granted restraining the implementation and execution or any decision, I believe, with respect to a recount. On appeal, the full court, sitting by the Learned Chief Justice and Justice Hardenan, discharged those orders, having found that that Justice Holder did not have jurisdiction. Your Honor, we applied to Justice Hardenan and the Chief Justice in the full court for leave to appeal, and that application was refused. It necessitated that we would consequently have had to file an application for leave to appeal, and in that motion we also sought that the hearing of the application for leave to appeal be treated as the hearing of the appeal. Your Honor, have regard to the circumstances which are restated in the press release and which appear quite imminent, and I wish for the court to observe that no such application was made prior to today's date, because we expected, Your Honor, that the Elections Commission would recognize that this constitutes a continuation of the legal proceedings, an effort to have these issues comprehensively resolved by the judicial system. With regret, Your Honor, the approach taken by the Chairman of the Elections Commission and the Commission as a whole seem to collide and run contrary to our understanding that this court is seized with this matter at this stage. In the circumstances, Your Honor, in order to ensure that the issues are ultimately capable of being decided, we respectfully ask the court, Your Honor, that interim orders be made pending the hearing and determination of the motion which is about to engage the court's process for consideration and ultimate adjudication. This court is seized with this matter at this stage. In the circumstances, Your Honor, in order to ensure that the issues are ultimately capable of being decided upon without any great prejudice to the case of the appellant, we respectfully ask the court, Your Honor, that interim orders be made pending the hearing and determination of the motion which is about to engage the court's process for consideration and ultimate adjudication.
Ms. Kite, anything you wish to say?
Your Honor, my first observation is that nothing was served on me. Nothing, as far as I know. I'm being told it was served at my chambers. I certainly was not aware of this affidavit. In respect to that, I would need to peruse it and take instructions from my client.
What is your response to the information that was just given to the court about the contents of the press release? What do you say? And of course, the court is now being asked to make interim orders. Is there any help you can give to the court?
In respect to such an important issue, I would prefer to have clear instructions from my clients, because like any other guidance, these are things I simply read in the press, and I would prefer to have instructions.
Please, Your Honor, may I give you this question?
Yes, please go ahead. Mr. Mendez?
Thank you very much, Your Honor. I noted that in the notice of motion that the appellant filed before this court, they asked for leave to appeal, and even though they had asked for a stay of the proposed order before the full court, they made no application for a stay, they made no application for an interim injunction pending the appeal. I made a note of that in circumstances where the full court had dismissed the application and specifically stated that the interim relief that had been granted was accordingly discharged. It is not new to anyone that the Commission had proceeded to meet, even yesterday when we were before the court. And not to sure exactly what is going on the ground in Guyana, of course, from this distance, but I don't think that there's any secret, or it would not have been a secret to anyone, certainly not to the other commissioners with whom the appellant is associated, that the Commission was proceeding on the basis that there was no order restraining them. So that an application could have been made to the Court of Appeal before. An application has not been made in writing. My learned friend is now making an oral application, and certainly there will have to be an adjudication on it after the court has heard full submissions on both sides as to whether an injunction ought to be issued. We will certainly be submitting, if an application is entertained, if you are entertaining the oral application, that one, there are no prospects of success, so therefore there is no proper basis for the grant of an injunction, and in any event, the appellant can point to no prejudice that will be suffered as a consequence of anything that the Commission will do going forward. And in any event, from the press release, we are not even clear as to exactly what they are going to do. All that they are doing is meeting, as far as I can read from the press release. So that you will have to receive full submissions and respectfully submit on the application that has been made. It just can't be given because the appellant has asked for it. First of all, we need to see the application in writing so that we'll be able to study it and make a response. We gathered here this morning, Your Honors, of course, to hear the substantive appeal. We've all turned over every rock in order to ensure ensure that you have as much material before you so that we can proceed with the appeal, and I would respectfully submit that that is what the court should hasten to do at this point in time.
Your Honor, I just wish to respond very briefly. Your Honor, this is part of the misconception that has been generated by the other side. I heard Learned Senior Counsel Mr. Mendez say that the appellant is associated with certain members of the Commission. I wish to state and put on record that this appellant, intended appellant, is in no way associated with any members of the Commission. Your Honor, this application arose because of a decision which is set out in the press release of the Commission, that it intends, firstly, to proceed to have a decision made on a recount. Another paragraph of the press release indicates, Your Honor, that the Chairman of the Elections Commission seek to have rejected, apparently, the report of the Chief Elections Officer. The application as filed, Your Honor, before the Justice Holder indicated clearly that it's the contention of the appellant, intended appellant, that the issue of the report moving from the Chief Elections Officer to the Commission is a matter that ought to have been done. So we see in the very document, Your Honor, a decision taken by the Chairman, apparently, to act contrary to what was the state of affairs and the issues being raised by the appellant. Your Honor, the fact that my learned friend have to retreat to the issue of prospects of success shows that in terms of the ultimate determination of this matter and the issues at this stage, Your Honor, that it is fit and proper that an interim order be made. Your Honor, in order to expedite this matter and to have it heard quickly and have a proper hearing and not a waste of judicial time, I respectfully submit, having regard to the peculiar circumstances of this case, there is no need for a written application. It would only serve to prolong and aggravate and delay the resolution of these issues. Your Honor, even though this is an oral application and it's not a written application, this court is seized with its own inherent authority and jurisdiction to make this order of its own motion without the applicant or the respondent seeking to intervene in any way to have this order made. We're not aware, Your Honor, whether the court would have seen the press release, and Your Honor would see that from the affidavit file, we deliberately made it non-contentious in any way. We did not make any comment or statement whatsoever in relation to the press release, but we wanted to bring to the court's attention that ultimately that these issues would render decisions made by this court potentially nugatory. Your Honor, the fact that the court has the inherent jurisdiction to make sure that its proceedings are sustainable, I ask that the court make interim order and we move straight into the hearing of the substantive issues, the reason why we gathered here today.
And what I'm saying, Your Honor, if I may, is that the application will have to be heard. Now, the defendants cannot get up and ask for an injunction and expect that it will be granted. An appeal does not operate as a stay, far less does the mere fact of the filing of appeal give you a right to injunctive relief. I'm simply saying that the application will have to be argued. He will have to be heard. I imagine that the chairperson will have to be heard, and Ms. Kite has already indicated that she would need instructions in order to be heard on the application.
I don't believe that my learned friend again is comprehending my submission to the court with the greatest of respect. We're not necessarily seeking an injunction, Your Honor. We're asking the court at this stage to protect its own jurisdiction, its own competence, and its own authority, and to make an order that preserves the status quo. The court is entitled to make a conservatory order or any order of the nature that it seems fit to ensure that ultimately that it cannot be done. Your Honor, I'm not only standing here as an attorney at law for the appellant, but I'm standing here as an attorney at law presenting to the court and urging the court to act on its own inherent jurisdiction, its own motion, having regard to the circumstances of this case, the urgency, the national importance of it, and to make an interim order of its own motion.
Okay, well, the court
Your Honor, in whatever way the learned friend puts it, however he describes the order, whether he's asking, I don't understand how he can apply to you to make an order of your own motion. He's asking you to make an order. We don't even know what the terms of the order is. All I'm saying is that whatever he's asking you to do, there needs to be a hearing on it. That is all I am saying.
All right, well, we would say at this point, we take Ms. Kite's response to the court's inquiry that she has no instructions. She is sitting here in the Court of Appeal representing the Commission. We note Mr. Ford's observation or his concern that the decision of the court may be rendered merely academic if what he's read in the press is true. Ms. Kite is not in a position to confirm what is taking place at the Commission at this time. And so the court, I think, ought to rely on Ms. Kite as an officer of the court to indicate any position at the Commission which may affect the matter before the court and the court's authority. But in any event, the court has already, having looked at the submissions that we have received, and we now have a sense of all the material that is before the court, except, of course, the oral arguments which will highlight those very submissions. The court will be delivering its ruling on Sunday at 11 a.m. So we put that out to the parties and counsel that on Sunday at 11 a.m. the court will be ruling on the entire application, the entire motion. And so, Ms. Kite, you will bear that in mind. And as I said, as an officer of the court, before we adjourn today, if there is any development that you think the court ought to be informed of, then please communicate it.
Much obliged, Your Honors. I certainly will indicate any information to the court. I would have been placed in a much better position if my learned friends had served this application to me, even here in court. Immediately I would have been able to call my client, but I was totally taken by surprise by this application. However, I will indicate to my client when the court will rule in this matter and all other information that may arise during the hearing this morning. Grateful, Your Honors.
Thank you, Ms. Kite.
Your Honor, this application was served at Ms. Kite's chambers. I had no idea that she did not have, it was served at Mr. Nandalal, I think it was served in Mr. Jonas' chambers. I think,
There's an affidavit.
yeah, it was served, the affidavit was served. Your Honor, Your Honor, I believe that, and I'm grateful for the court's approach to the issue so far, Your Honor. But Your Honor, I believe whilst the matter proceeds this morning,
All right, Mr. Ford, the court has already expressed its expectations to Ms. Kite. And so Ms. Kite is here.
Yes, sir.
And is in communication, we expect, with her client. And so we will proceed with the hearing, and as the court said to Ms. Kite, if there are developments that affect the authority of the court's ruling, that we expect those developments will be communicated to the court.
Thank you.
So we will move now to the hearing of the motion. It's now 10:30. And so, Mr. Ford, you have until, let's say you have until 11:05.
Thank you very much, Your Honor. Your Honor, Mr. Francis Alexis, Dr. Francis Alexis, and Mr. Keith Scotland will be presenting the oral arguments on behalf.
And Mr. Scotland, please go ahead.
Good morning. Morning, my ladies, my lord. I, Keith Scotland, my lord, have been given the task of Roy Fredericks. So I will open the innings in this matter. My lord, ladies, the first point relates to whether or not this is a matter which the appellant has a right to appeal, or whether leave ought to be sought. We submit in the first instance that in this matter it is a right of appeal. We rely on our submissions filed herein, the first set of submissions from paragraphs 15 onwards to 25, but we supplemented with oral submissions having received the reply from the first respondent, the seventh respondent, and we say as follows: the decision that we seek to appeal is a decision of the full court, and it is a final decision in that it determines the rights of the parties finally. My lords and ladies, that is now conceded by the respondent, the seventh respondent, at paragraph 4 of their reply. What the seventh respondent now seeks to do is to say, in any event, that it is not an appeal of right because it falls under section 62(2)(a)(I), in that it seems to be an order of a judge of the High Court made in chambers or in summary proceedings. And the seventh respondent praised aid of the case of Facade and Nazimadi in order to support this contention. We say, with respect, that this appeal and the circumstances set out by the seventh respondent submissions applies only to an order of a judge in the High Court made in chambers or in summary proceedings. This matter does not concern either an order of the judge of the High Court or touches a matter of summary proceedings because it is an appeal against an order of the full court. In any event, we say that Facade and Nazimadi is distinguished because this appeal is not an appeal from summary proceedings. In other words, this is not where the learned trial judge gave a judgment, even a fixed date claim for, in a summary proceedings. This is an appeal where the seventh respondent appealed the decision of the judge, and we are now seeking leave to appeal the decision of the full court. If we are wrong in this regard, we say respectfully that we meet the criteria set out in section 6(4) of the Act. And my lords and ladies, may I briefly take your lordship's attention to the judgment of the full court in this matter. Does the court have a copy of this judgment?
Yes, we do.
We have relied on, in our main submissions, the case, the Trinidadian case of Ocean View Development and Deodat Marad, that is cited at paragraph 32 of our primary submissions, and the dicta of Justice of Appeal Weeks, as she then was, in that leave will be granted if the appellant shows, and we quote, advance a case capable of being advanced, or some other compelling reason which includes the public interest or elucidation on a point of law which needs to be advanced. Does your lordship, my lord, have that?
Yes, we have your submissions.
Right. We now ask the court respectfully to turn to paragraph 14 and 15 of the judgment of the full court. 14 and 15, which is at pages 9 and 10. Paragraph 14 starts as follows. Does your lordship have it?
Yes, we do.
This appeal raises a number of important issues. Turn over page. Whether and it outlines the three issues, but it goes further. At paragraph 15, this is what the full court had to say. We have noted the submissions on the ground of the state. Given the weighty issues to be determined, we have decided to reserve judgment while being mindful of the urgency of this case. The full court itself recognizes that not only are these issues raised are important issues of law and they identify it, but they add importance to weighty. We say respectfully, if we are wrong on our initial point, that it's an appeal as of right, we then say we fall within the category of important and weighty issues which the court ought to grant us leave, exercising its discretion to appeal under the legislative framework of section 6.4. Unless I can give any further assistance on that point, I would then respectfully submit that 1, we are entitled to leave as of right. 2, if we are wrong on that score, we have more than crossed the threshold test of important and weighty issues to be decided by this Court of Appeal. The next issue I intend to respectfully address is whether the full court erred in the exercise of its discretion relative to hearing an interlocutory appeal during the pendency of a trial before Justice Holder. My Lord Lady, again, we rely on our written submissions, but the fifth, the senior counsel, Mr. Jeremy, will always tell me of our argument, starts with the reasoning of the full court at paragraph 32. This is the reasoning, this is what the full court bases its decision to allow this appeal and to entertain or to exercise its discretion. And the court will see that we refer to what was stated therein, and starting with this fundamental principle, it seems that the court reasoned that the singular determination of a question of jurisdiction will decide if the case goes on. And then the court said, this is an exceptional circumstance. My Lord, Lady, we respectfully say that the full court plainly erred in law by coming to that conclusion, because there was no evidence brought before it of any exceptional circumstance, because the effect of a judgment on jurisdiction, if upheld by a superior court, brings a matter to an end. That is not an exceptional circumstance, that is commonplace. That happens every day. So every time, if you take the logical extension of the reasoning of the full court, every time a matter is before a judge in first instance, and a litigant raises a matter of jurisdiction, the court must, or a limitation point, the court must stop the matter, walk to the court, decide on it, because it's an exceptional circumstance. My Lord, my Lady, that is respectfully, plainly wrong. Because jurisdiction points are commonplace. And I also ask the court to note that the evidence before the full court on this matter, the only evidence before the full court, was contained at paragraph 15 of the affidavit of the seventh respondent, Barrett Jackie. So in these circumstances, we say, whether or not the court wants to say it was plainly wrong or erred in law, the full court just got it Wrong. There were no exceptional circumstances warranting the exercise of the discretion in this matter. The last point I wish to address this court
on that point, Mr. Scotland, could it be that the court considered the national importance of the matter?
Probably, I am not.
Could it be that the full court considered the importance of the national importance of the matter, and the time factor, and also, as the court said, that the jurisdiction point was going to determine the entire case. So could those have been the exceptional factors that caused the court to have treated with the matter in that way, as exceptional? What do you say?
I say that, I firstly say that what I have is the written judgment of the court at paragraph 32, which expresses the thought process of the court. And what this court has alluded to, although there are factors that a court can take into consideration, was not taken into consideration at paragraph 32. I now frontally answer your ladyship's question. Yes, those are issues that may be considered, but they are not exceptional, because every case of jurisdiction, if a superior court upholds it, will bring the matter to an end. And my lords and ladies, in terms of timing, this matter was before Justice Holder, and he was already prepared. All he brought us back for Monday afternoon at 1 was to clear cobwebs. Those are the words he used. And he was prepared to render a decision within short thrift. In other words, my lords and ladies, the time factor in the court considering it at the full court level has to be balanced on the stage at which the trial was advanced before the trial judge. There was no cross-examination, there was no issue to be determined of witnesses to be deposed on. In fact, my lords and ladies, submissions on the final and the core issue were already in. So if the court considered that, then the court had to balance that with what I've just said there, please, my lady.
Please go ahead.
My last point is the constitutionality of Section 22. My lords and ladies, the respondents, 7 respondents, at paragraph 45 to 57 of its reply, take several what the CPR considers, with the greatest of respect, arid technical complaints. So the first technical complaint is, well, you didn't serve the Attorney General, and that is fundamental. I don't know, and I'm subject to what the court has to say as to whether there's a sitting Attorney General in this time, but if there is, that's a technical point that was taken. The next point is, well, and also, we say in answer to that will apply only if you seek a relief against the state. In other words, well, you have infringed my constitutional right by wrongfully imprisoning me, and I take the point before the court. That is not a matter that is germane in this point. In this case, the germane issue, there's a section that is frontally before this court, which was relied on by the full court, and it's, in its own words, operationalizes the powers of GCOM. And we say, respectfully, that the constitutional point ought to be entertained. We also say, my lords, my lady, and I want the court to carefully consider the reply of the respondent. At paragraph 58, the respondent's constitutional conscience kicked in. They really agreed that the provision may be unconstitutional, but say sever it. We say that section 22 from 58 onwards, that is how I have read it, we say that it is not severable, it is unconstitutional, and the court has the jurisdiction to entertain the constitutional point. My Lord, my lady, we just had two cases on point which we, I think, passed up, which is Vincent and Flossack, in which a point was raised on the Constitution right before the Court of Appeal. And of course, we also had the case of Diamond Text, a case of the Court of Appeal in Trinidad and Tobago, which says that the court can entertain, does have the power to entertain a point of law raised first time before. My Lord, my lady, we rely. I now hand over to Dr. Alexis, unless I can assist the court any further.
Thank you, Mr. Scotland. We'll hear now. Thank you. We'll hear Dr. Alexis.
Good morning, Your Honors. Much obliged for hearing me. I wish to show that there is reasonable prospect of success regarding the ruling of the full court that 1. The constitutional issues raised herein by Ulita Moore should be taken at an election petition point. 2. That section 22, my learned friend Mr. Scotland was just referring to, can do what the full court sought to do with it. I take first the matter of what is the proper forum for Ulita Moore's constitutional issues. The core narrow issue taken by Ulita Moore is set out in paragraph 79 of submissions on behalf of the appellant, the 62-page document, Your Honors, and simply it is whether the chairman and GCOM may refuse to perform the functions reposed in them, respectively, on the chairman to declare a person to be deemed to be elected as President of Guyana under Article 177, paragraph 2 of the Constitution, and on GCOM to declare a winning list of candidates under Section 99 of the RTA, and very importantly, Your Honors, only because the chairman seeks to cooperate with the agreement. When the agreement, the appellant contends, is consistent with various articles of the Constitution. That core issue, Your Honors, is not an election dispute for an election petition court regulated conjointly by Article 163 of the Republic and by the Section 3 of what might be called the election petition law, namely the National Assembly Validity of Elections Act. Your Honors, not every question regarding an election is an election dispute to which applies the election petition regime. We make that point in paragraph 96 of our principal submissions to this Honorable Court. A striking election question, which is an exception to the election petition regime, is hammered against the returning officer. We discussed that case fully in paragraph 97 of our main submissions. Thusly, Your Honors, That case decided by the Honorable Chief Justice lays down the complaint about non-compliance to Section 84, subsection 1 of the RPA, Implementation of the People's Act, is an exception to the election petition regime. That being so, Yulita Moore's complaint non-performance of functions regarding the supreme law of the Republic. Article 177 set down by that same Act, Section 99. But what is more is this. Yulita Moore complains about non-performance of functions regarding the supreme law of the Republic. Article 177, paragraph 2. Furthermore, Your Honors, Yulita Moore complains that such non-performance is aimed deliberately at achieving cooperation with an agreement which she contends violates several provisions of the Constitution. That is set out in paragraph 100 of our main submissions to this court. Moore presents not an issue affecting the election results per se. I copy those words from the very Chief Justice herself, paragraph 79 of Her Honor's judgment, full court's judgment. Instead, Moore presents questions whose proper determination requires interpretation of the Constitution. And that is fundamental to this case. Namely, that the proper determination of the questions presented by Moore requires interpretation of the Constitution. And of course, Your Honor, the rule of law requires that the chairman and GCOM, on the one hand, be treated the same way as the returning officer in holiday. You have one rule for holiday, returning officer there, and another different rule for the chairman and GCOM. Let us then, if we may, look at the extent to which Moore makes out prima facie that the agreement violates several provisions of the Constitution. Paragraphs 107 to 110 of our main submissions. The selection and appointment of members of GCOM, those matters are regulated strictly by the Constitution. By contrast, the selection and appointment of members of what may be referred to as Team CARICOM, meaning the high-level team referred to in the agreement, the selection and appointment of those persons is not addressed at all. So they may be selected and appointed entirely differently from the way the members of GCOM are selected and appointed. Then there is a question of supervision. Paragraphs 111 to 128. Sacrosanct to the Constitution is the matter of the supervision of elections set out, referred to in Article 162 of the Constitution. That's right, 162 paragraph 1. The key word in this whole paragraph is the word supervision over the administrative conduct of elections. But what do we see in the agreement? That the same word, supervision, is entrusted to Team CARICOM. That's a clear conflict. Nor is Team CARICOM any observer. We addressed that in paragraphs 129 to 130. Nor is Team CARICOM a delegate of GCOM. We addressed that in paragraphs 131 and 135. On the contrary, Your Honors, the intent of that agreement is to put in place dictation on the part of Team CARICOM to the constitutional authority of this country, Guyana, namely GCOM and the chairman. The agreement is therefore usurping the powers of GCOM and the chairperson, requiring GCOM and the chairperson to abdicate their responsibility, particularly in the case of the chairman, whose responsibility is addressed specifically by Article 177, paragraph 2, and forcing GCOM and the chairperson to surrender their respectively constitutional and statutory duties. No wonder, Your Honor, the agreement itself describes Team CARICOM as being independent. I ask Your Honor to underline that word, because it makes Team CARICOM independent both of the chairperson and of GCOM. But it is attempted to be said that GCOM ordered a recount and that Team CARICOM is coming into the country only to assist them. What went on in that press release this morning is an eye-opener about that. Because if there is anything good about that press release, is that it underlines the fact that GCOM had never ordered any recount. Before the full court, a learned friend of mine, Mr. Jonas, invoked an affidavit by Mr. Lowenthal, and we refer to paragraphs 59 and 61. Your Honors will read those two paragraphs and see there is nothing in there, could not have been anything in there about GCOM ordering any recount. And thanks to the press release for that. Instead, Your Honors will get good guidance from the affidavit by Corbin, and member of the Commission, paragraphs 4 and 5, where he deposes what the press release just being referred to now supports, that there was never any order made by GCOM for a recount. Nor can GCOM do so now, because they will be engaging in abdicating and surrendering their responsibilities. Those differences between the Constitution and the agreement, those inconsistencies, condemn the agreement. For paragraphs 154 to 156. There can be no doubt that your honors have jurisdiction to supervise the GCOM and the chairperson. But we are asked to respond to section 140 of the RPA with its outer clause.
One question, Dr. Alexis.
Your Honor.
You said the court has jurisdiction to supervise GCOM and the chairman. If the court accepts that, what would be the nature of that jurisdiction? Would it be to point GCOM to Article 62? We didn't mention Article 62, but that essentially says that GCOM is in charge of independently managing elections. Is it that the court will point GCOM in that direction, or in the direction of Article 162, and leave it there? Is that the jurisdiction that the court has if we accept your submissions? Or is it a jurisdiction to direct GCOM to go to perform its functions on the, as you say, Article 177 and Article or Section 99? Is that, what is the nature of the jurisdiction of the court? How far is the court to go in exercising that jurisdiction if we accept that the court does have that supervisory jurisdiction?
Much obliged, Your Honor. The Caribbean Court of Justice answered that question in Ventos and Chief Election Officer. Because in that case, the Caribbean Court of Justice unanimously ordered the Chief Elections Officer of Barbados to carry out his function in a particular way, namely to register Ventos as a voter so that he could vote. The CCJ didn't just simply say, go now, Chief Election Officer, and perform your duty according to law. No, Your Honors. CCJ told him or how to do it, namely to register Ventos. Similarly, the Privy Council in Rajkumar and Lala made it clear, the Trinidadian case, it's in our bundles, that where a body to be supervised by Your Honor's court is not doing what it should do only because of unlawfulness and reaching a decision other than that which is, so to speak, the only cognizable decision in the circumstances, then the review court reserves the right, and indeed may have a duty to order the entity to perform its duty in a particular way. In other words, we are light years away from Hatfield, Minister of Agriculture Fisheries, where a review court just simply said to an entity, go now and perform your duties according to law. We have moved away from that. See Ventos, see Rajkumar, Lab. Therefore, if Your Honor is satisfied that Article 62, Article 162, Article 172 is not being adhered to by the chairman, and particularly on the unsustainable ground that it seeks to achieve cooperation with an unconstitutional measure, then Your Honors are in a position to make an order similar to what I may respectfully call the Ventos order. So we recommend the Ventos kind of order to Your Honors. If I have your honors leave me, I
Yes.
continue.
Well, you have, you've exceeded your time. How much more time do you need?
5 minutes, please.
Yes,
Your Honor.
please go ahead.
Much obliged, Your Honor. We say that section 140 of the RPA does not assist the respondents. First of all, Hollidar was dealing with acts. The RO presented results for the tabulating of 458 SOPs, for which the tallying took place while he was in hospital, unfortunately. Whereas more is about omission, and we developed that in paragraph 148. The distinction between acts and omissions is well known to public law. See, please, Your Honors, the Constitution itself, section 163, 1B, Roman numeral 1, section 3, National Assembly Validity of Elections Act, and when you go, Your Honors, to the Judicial Review Act, numerous sections there, section 3, 4, and 5. The full court did not do justice to this learning. I don't have to take your honors to Anna Smith and Sortilal and Fraser except to say this. The sent respondent in particular seeks to impress upon your honors that this is an exception to Annis Minnick. Annis Minnick, if it is susceptible to exceptions, would be these: an inquiry to be initiated in time allowed. 2, inquiry permitted by a particular statutory route. And they refer to 2 cases: Director of Department of Security Services and Farley. Those 2 cases are to be read now in light of what we say in our further submissions this morning, paragraphs 18 to 19, where the United Kingdom Supreme Court is doing 2 things. Making the point that those 2 exceptions have to be put in the context of parliamentary sovereignty. And secondly, the United Kingdom Supreme Court emphatically reaffirmed Annis Minnick. Now, Your Honors, neither of those 2 exceptions applies to Moore. First of all, the attempt to shunt Ms. Moore to the election petition court fails because the election court is an extremely special court, Petrie and the AG. It has its own self-contained powers and jurisdiction. And this is the point, Your Honors. Only the constitutional jurisdiction of the High Court of this country has jurisdiction to engage in interpretation of the Constitution. And that is the point underlying Article 133, Paragraph 1, Clause 8. And the respondents miss this completely when they refer to Attorney General and Dumas in paragraph 16. What the Privy Council is saying in that paragraph is that they are recognizing that the High Court is the forum for dealing with interpretation of the Constitution. And we have a case from Uganda, Jude and Sikandi, which focuses on the difference between 1, interpretation of the Constitution by the Constitutional Court, and 2, proceedings before an election petition court where constitutional issues might arise. I know my time is against me, so I just have to leave that there for the time being. My friends on the other side referred to Peters and Triton. I ask your honors to read paragraph 43 of the supplementary submissions put in this morning by the Senate respondent. Because in that paragraph, your honors will see the Court of Appeal of Trinidad and Tobago is making the clear point forcefully that what they are saying is a context in which interpretation of the Constitution as such is not germane to the proceedings before the election petition court. And as for section 22 of the Election Laws Act, which operationalizes it, we just said, full court said, if the full court ruling is correct on this, section 22 is clearly unconstitutional. And we have set that out in our paragraphs. Therefore, your honors, in closing, let me say this. It is in the interest of all, not least the respondents, that the constitutional issues raised by Eureka Moore be determined as to their substantiality. Not answering them substantively leaves a cloud over what is being attempted in the agreement and what is being not done by the respondents. No one profits from that. Let then Moore's application substantively be heard and determined in the interest of all, lest history not absolve the respondents. That is our submission. May it please your honors.
Thank you. Mr. Mendez.
Much obliged to your honors. History shows that as far as raising constitutional questions that impact upon an election, the courts of Guyana have consistently held that they must be raised and can only be raised in an election petition. And of course, the 1980 Constitution, therefore, has to be interpreted in the context of the way in which the Guyanese courts have approached this question prior to the 1988 Constitution coming into force. One of the cases relied upon by the appellant in their submissions is the case of Petrie against the Attorney General, a case which has been referred to in numerous cases right across the Caribbean, recently referred to in approval by the CCJ in the Christopher decision. It's also referred to by the Court of Appeal of Trinidad and Tobago in the Chaitan and Peters decision. In other words, it is a decision which has stood the test of time. Your honors, I took the precaution of handing up copies of those cases to you. I hope you have.
Yes, we have received them. Yes, we've received the treat.
What should I say? Now, that was a decision of Chief Justice Wallace in 1968. That was a case where, after the election had been called, a constitutional motion had been filed seeking declarations that an act of parliament and the regulations under which elections were to be held was unconstitutional. That was the proceedings that were launched after the Governor General had called the election. And at the end of the day, what the Chief Justice held, and apparently this decision was not appealed, was that the constitutionality of the very act and regulations governing elections would be a point which would have to be taken on an election petition. If you look at page 297 of the decision, at letter B, you'll see the argument that counsel made in that case, which is very reminiscent of the argument that is now being made, and it is recorded as follows, just at letter B. Counsel for the plaintiffs in reply to these submissions made by the Attorney General, while not conceding that any special jurisdiction was conferred on the High Court by the Constitution by virtue of Article 71, Article 71 is equivalent of Article 163, admitted that the High Court, in its general jurisdiction of common law, had jurisdiction to entertain these proceedings. Submitted that common law, the court does have jurisdiction to interpret the Constitution, where the question of interpretation is being raised in these proceedings. Similar to the submission that my learned friend Dr. Alexis just made. And those questions necessarily arose in view of the form of the action. Counsel pointed to Article 92(1)(a), which deals with appeals. That's equivalent of Article 133 that my learned friends also rely on, which states that an appeal to the Court of Appeal shall lie as of right from decisions of the High Court in certain cases. That is to say, final decisions in civil and criminal matters as questions on interpretation, and submitted that it would follow that the common law of the High Court would have jurisdiction in relation to any matter involving interpretation of the Constitution, etc. And then if I can ask you to go down to page 302 of that decision. At the letter H, you will see the way in which the Chief Justice posed the question. He said, I agree with the submission, but the question which the court has to consider under the paragraph are whether there is some general illegality either affecting the whole election or the election held in some particular place, or the absence of a general illegality, whether there has been some specific illegality being an act, either an act or an omission which affects the result of the election. So that is how we pose the question, and of course that is the very language that is used in Article 163(1)(a) of the Constitution, on which we say the issues raised by the learned friend naturally fall. And if you look at from the bottom of page 304 over, this is how the Chief Justice dealt with the matter. About 4 lines from the bottom, it says the Attorney General submitted that the wording of Article 71(1)(b), equivalent to 163(1)(b), do not contemplate a situation where a party was urging that an act of Parliament was illegal, null and void, and ultra violates the Constitution, as in this case, but is intended to cover cases where, as a result of an unlawful act or omission done in pursuance of an act of Parliament presumed to be valid, made in an election and not lawfully conducted or affected the result thereof. In other words, his contention was when the framers of the Constitution used the language contained in Article 71(1)(b), that is, whether either generally or in any particular place an election has been lawfully conducted or the result thereof has been or may have been affected by any unlawful act or commission, is the identical wording that we are dealing with. The intention was to exclude any act of Parliament that might be invalid as ultra vires the Constitution, and to presume that the act of Parliament was valid, but that any unlawful act or omission done in pursuance of the valid act would cause an election not to be lawfully conducted or affect or may have affected the result of the election. Follows therefore from the contention of counsel that the words whether an election has been lawfully conducted must be interpreted to mean only unlawful acts or omissions which spring from a valid act of Parliament intra vires the Constitution. Now, that certainly covers the new point that has been raised within the last 24 hours as to the constitutionality of Section 22 of the Election Laws Amendment Act. That is to say, the appellant now wishes to challenge the constitutionality of a specific provision on which the Commission is relying. But it also covers the allegations that are being made against the Commission that its acts are ultra vires the Constitution. And the learned friend Dr. Alexis is saying he is entitled to raise those now because he is raising questions that require the interpretation of the Constitution and a determination as to the constitutionality of the act. And this is what Chief Justice Bonner said. I cannot accept this submission as there is nothing in the language used to suggest that the words I'm reading at just below letter C on page 305.
Well, we have the printout which is not paginated in the same way, because this was not loaded. So we will listen to what you say.
I'm terribly sorry, Your Honor.
Please go ahead.
Thank you. I cannot set this submission as there is nothing in the language used to suggest that the words lawfully conducted must be confined to unlawful acts or omissions done in pursuance of a valid intra-virus the Constitution. Surely of an act of Parliament on which and by virtue of which an election is conducted is ultra-virus the Constitution, then it cannot be said that the election has been lawfully conducted, or anything done on this invalid act must be unlawful, null and void. As was stated by Justice Fazal Ali in the Konuswamy case, any matter which has the effect of vitiating an election and an act of Parliament which is ultra-virus the Constitution, on which acts are done for the purpose of holding an election, must have the effect of vitiating an election, should be brought up at an appropriate stage and should not be brought up at an intermediate stage before any court. And then he goes on to say there was a consequence. He accepts the submission of the Attorney General that the constitutionality of the act governing elections, the entire act governing elections, not a particular section, not the constitutionality of the conduct of election officials, but an entire act. So if you're raising that, you must raise it on the election petition. Now that decision, as I said, has stood the test of time. It was followed in the Kumar Singh case in 1973, another decision of Chief Justice Ballers, in which another attempt was made to challenge the constitutionality of an act of Parliament, and the Chief Justice Ballers made the same point again. You will see at from pages 46 over to 48, which I will not read, but the same point is being made. The same argument was made, which is that the equivalent of Article 163 1B of the Constitution, when it speaks of an unlawful election, is not talking about an unconstitutional election, but it is presuming that the legislation under which the election officials are acting are intra-virus to the Constitution. That argument was made again in 1973 and rejected again by Chief Justice Ballers, and the point was made: if you're going to raise the constitutionality of an act of Parliament, you must raise it in an election petition, which I respectfully submit answers the question whether you can raise constitutional issues, that is to say, complaints of breaches of the Constitution, in an election petition. And the answer is resoundingly yes, you can. That is the jurisprudence that existed undisturbed when the 1980 Constitution came into force, and the provisions that we are now interpreting were then brought into force, largely repeating the provisions that were under consideration in Petrie and Sikumar. So that the framers of the Constitution knew what the law was, knew what the jurisprudence was, and they made no effort to change it. Then we have the more recent decision in, I think it's Esther Pereira. I just have extracted it at this point in time. She also handed up, which coincidentally is a decision of Justice Claudette King. And this is a decision on an election petition, in which, in that election petition, the question of the constitutionality of a provision of the Act was questioned. And you will see at page 4 of that decision, this is the argument that was made, that the requirement of the voter's ID card as a qualification to be an elector at an election is provided for under the Election Laws Amendment Act 1997 is ultra-virus with Article 159 of the Constitution of Guyana. That question was raised, and you'll see at page 17, this is since the constitutional right to vote is conferred by Article 59 and is based on qualification, which the prohibition or restriction on the exercise of this right arises under Article 59 and is based on non-registration. And she goes on to make the finding later on that the particular provision of the Election Laws Amendment Act 1997 was in fact unconstitutional. This you will see at page you'll see at the bottom of page 76, which says, I find that the victim of Boris CJ and Gladys Petrie and Attorney General aptly states the law. Surely one has to format on which and by virtue of which an election is conducted is outre violates the Constitution, then it cannot be said that the election has been lawfully conducted. But anything done under an invalid act must be unlawful, null and void. And she says, accordingly, I pose that the 1997 elections were not conducted in accordance with the law. So she makes a finding on an election petition that an election which was conducted on the basis of an unconstitutional law is an election not conducted lawfully within the terms of Article 163 of the Constitution. And on that basis, she declares the election to be invalid. So contrary to the submissions that the learned friend has been making, that the questions of the constitutionality of Section 22 of the Election Laws Amendment Act and the constitutionality of the acts of the Commission, contrary to the submission that those cannot be raised in the election petition, here are three authorities that indicate very clearly of long-standing, never been overturned, but the appellant can raise all of these constitutional questions on an election petition. And the ruling in both Petrie and Sikumar is that is where you must raise it. You don't have a choice. You must raise it there. Jurisprudence has been upheld by the CCJ in the Christopher Ram case, where the CCJ held that the election petition procedure is an exclusive and compulsory process. And it is an exclusive and compulsory process for all of the constitutional issues that the appellant has raised in this matter. That jurisprudence is confirmed by the Trinidad and Tobago Court of Appeal in Peters and Chaitan. It is confirmed by the Eastern Caribbean Court of Appeal in the Parry and Joseph case that we have cited. In that case, an allegation of breach of constitutional rights was raised on an election petition, and the Eastern Caribbean Court of Appeal determined affirmatively that the court exercising its election jurisdiction can entertain constitutional issues. So that is the jurisprudence throughout the region. Piggybacking on the Guyanese jurisprudence since 1968, and yet still in the face of that, the appellant is asking this court to say, well, we can hear these constitutional issues now, and you can't. I think this is what Dr. Alexis is saying. You can't raise it on an election petition now. On election petition, you have to deal with it now. The cases say otherwise, and I just note in passing that this jurisprudence is well known to the learned friend Mr. Ford, because he was in the Esther Pereira case. I'm not too sure what position he took then. But in any event, Your Honours, that is the position on the basis of the general jurisprudence in relation to the exclusive jurisdiction of the High Court in the election petitions. And I haven't come to section 140 of the Representation of People Act yet. That section confirms that jurisprudence. It confirms it by making it clear in relation, because that section is focused now on the Commission. And it makes it clear that if you are challenging the exercise of the functions of the Commission, then you must go by way of election petition. To that extent, we didn't need to rely on section 140, because the jurisprudence is so clear coming out of Petrie and Sikumar. And the fact is that as far as we look at section 140 by itself, the authorities of Farley and the Director of Establishment's case in the House of Lords and UK Supreme Court established that a provision such as section 140 is not even termed an ouster clause to which arithmetic applies, because it doesn't actually take away the jurisdiction of the court to scrutinize the legality of the actions of the Commission. What it says is, come to the High Court, but by way of election petition. That is what it says. So again, it affirms what Captain Kumar has said since 1968. Come to the election court to raise these issues. We cannot raise them now. I just wish to deal very briefly with the learned friend's point that he's not talking about performance, he's talking about non-performance. We have dealt with that point over and over in the submissions. I just want to make the point very briefly again, that the fact is that this entire case has been mounted as a challenge to the Commission's decision to have a recount. On the question whether there was such a decision, the then friend Dr. Alexis is suggesting there was none. I point, and I only need to point to the letter written by the Chief Elections Officer, which is on the record, in which he was telling the PDP's election agent, Mr. Mustafa, that a count is going to start, I can't remember the date that he said, on the 17th of March, but there was going to be a count on the 17th of March. Appoint your agent. That is what brought about these proceedings, beginning with an injunction to stop that from happening. So what they were challenging is not non-performance, they were challenging a specific act, that is to say the holding of a recount. And they were challenging the exercise of the Commission's power under Section 23 of the Election Laws Amendment Act. And they must have been challenging that because they have seen it fit now to challenge the constitutionality of that section. It's not about non-performance at all. It is about the performance of the Commission's function under Section 22. And it is a mischaracterization of the issues in these proceedings to say it is not about performance. It is a total mischaracterization.
So, Mr. Mendez, you say that that submission by Dr. Alexis, that part of the case is that those persons, the chairman, perform that task on the Article 177, and the Chief Elections Officer perform the task on the Section 99 of the Act, Representation of the People Act. That's not also part of the application? Is it just the holding of the recount, or is it also the further requirement that beyond that you also perform those tasks? That's why the court asked, well, is the court to tell the Commission that? And then we heard his answer. So I'm just asking, what's your response to the 177 and Section 99 submission?
I appreciate it. Much obliged. There is no evidence in the case that the Commission or the chair of the Commission is refusing to exercise powers or duties under Article 177 or Section 99 of the Representation of the People Act. What happened in this case is that the Commission, as I've already indicated, decided to have a recount. Mr. Lowenthal has testified that an order was prepared, and he exhibited the order indicating that the Commission was invoking Article 162 of the Constitution and Section 22 of the Election Laws Amendment Act. And the body of that order indicates that a recount was to be held, and the modalities of that recount was set out there. The order was not implemented because of the injunction in this case. So it stopped there. So the evidence therefore indicates that what the Commission was doing was exercising its powers as it saw fit, as it interpreted its powers under Article 162 and Section 22. So as far as they were concerned, they had not yet come to a Section 99 or an Article 177 position, because they were exercising their interim powers, as it were, to correct difficulties that had arisen. That is where we got to. So this is not a simple case of I'm refusing to do what I'm supposed to do. This is a case where they were exercising powers that are described in Article 162 and Section 22. And the point is that if they are right, that they have the powers under those sections to order a recount, then that is what they must do first. And it is only after they do that, if they are doing it lawfully and properly, that you get to the question, well, what do you do, or what are you required to do under Section 99? This is why we respectfully submit that this case is not about the failure to perform 99 and 177. It is about the legality of the performance of their functions under Section 22 in particular. That's what it is about, and we must be fair and direct and honest about what this case is about. It is an attack on the exercise of that power. Simpliciter. And as a matter of fact, Mr. Lowenthal himself has said in his evidence, the Chief Elections Officer, maybe one of my colleagues in the report there might be able to point you to it. But he said in his evidence that he hadn't submitted the report yet to the Commission. He himself said that. He himself, in his evidence, Chief Elections Officer, is talking about the intermediate step that was being taken to hold the recount. So we haven't gotten to a Section 99 status yet. He himself has put evidence before the court as to what the Commission was doing, that is to say, holding the recount. Whether that recount is lawful or not is a matter, whether that recount is unlawful because it breaches the Representation of the People Act, or it breaches the Constitution, or the power under which they are acting, that is Section 22, is unconstitutional. All of those questions go to the legality, the lawfulness of the election, and all of them not only can, but must be raised in an election petition. That is the end result of all of the authorities that have been put before you. Now, if I may just repeat a couple of points, Professor Bentos' litigation, now Justice Bentos, that was litigation that occurred before an election, before the election itself was held, and it concerned the specific point as to whether Professor Bentos' name should have been put on the list of electors. He was trying to assert his right to vote, and he was being prevented from doing so because of a misinterpretation of the Act. That was an occasion occurring before the election was held, and it is entirely distinguishable from what we're talking about now. Not too sure how much time I have left, Your Honor, but I wasn't keeping track. It seems that I'm not outside of my time as yet. But just a couple of points. To deal with the Linifred, Mr. Scotland's challenge to he is saying that the fact that the jurisdictional point would have determined the entire proceedings, he's saying that is not exceptional, but he does not deal or address the decisions that we have put before the court from the Trinidad Court of Appeal, in which that court was very clear that if you are challenging the jurisdiction of the tribunal below, that is an issue, particularly if it has legs as it were, that should be resolved as soon as possible, rather than allowing the proceedings to when they way to the end, only to find out later on that the court had no jurisdiction. And those were cases dealing with criminal proceedings. And in criminal proceedings, as I think this point has been made by my learned friends, in criminal proceedings, courts are generally speaking reluctant to intervene in criminal proceedings. But the Court of Appeal has said that when you raise a question of jurisdiction, that is one of the exceptional circumstances which will justify intervention. Respectfully, in these proceedings, to be generous as well, that is to say, election matters, I can put it broadly speaking. It is an exceptional circumstance where you challenge the jurisdiction of the court to hear the matter rather than allowing it to do the election petition proceeding. Because, as the CCJ pointed out in Christopher Ram's, the whole purpose of insisting that you go by way of the election petition route is that if you do otherwise, then you slow down the entire election process and you delay the point in time when the government can be declared, the winner can be declared. That is precisely why the courts have justified the jurisprudence that you go by way of election petition. That is stated very clearly in Justice Solom's decision. In this case, that is an exceptional circumstance because it appears clear to the court, as it appeared very clearly to the full court, that the lower court had no jurisdiction to proceed with the matter. Then what is the point of saying, well, I'm not going to rule on it, I'm going to let the court go ahead and make its rulings, and then we have to wait until that is finished before an appeal is lodged to the Court of Appeals. What is the point of that? When the full court obviously formed a view that the jurisdictional question was certainly a serious one, but ought to be dealt with as a matter of priority in order that we don't disrupt the settled jurisprudence, that you don't raise these issues before the election is declared, to do it after the election is declared by way of election petition. This situation of election petitions and the way the court exercises jurisdiction is sui generis, and it is even more important that if a jurisdictional question is raised, that it be determined swiftly and right off the bat. And therefore, I respectfully submit that it is not possible to say that the full court was plainly wrong or that they made any error in principle. Your Honor, I don't know what your point of view is. You may be of a different view. You may take a different view as to how it should have been approached, but whether you have a different view or not is not to the point. You will have to make a determination that no reasonable court could come to that conclusion. It will have to be a perverse decision, in other words, on the part of the full court, for you to intervene in the exercise of their discretion. I respectfully submit that that is not this case here. Let me just check my notes to see if there are any other points that I want to extend to. Dr. Alexis is relying on Polidera. Polidera, you will see from the decision of the Chief Justice in Polidera that although she said that the court would intervene, the allegation in that case was that the returning officer did not conduct the count in the presence of persons who were entitled to be there. She nevertheless held that she would not entertain, the court would not assume jurisdiction where the allegation in relation to the allegation in relation to what the returning officer was doing under 84.1 was that he was not actually adding up the votes on the statement of pool, but he was getting the figures from somewhere else. She said that is not an allegation that she would entertain, even though Section 84.1 says the returning officer must add up. And she also said that she would not entertain at this stage any complaint that the request for the final count under Section 84.2 was invalidly refused. She said she's not entertaining that either. So that the welfare cannot take part of Polidera and ignore the other parts. Polidera would have to be treated as an exceptional case as far as this jurisprudence is concerned. But it is clear, absolutely clear, from Petrie, Tikumar, Chaitan, Parian Joseph, Esther Pereira, that all of the issues that the appellant has raised in this matter are issues which are not only appropriate for election petition proceedings, but can only be raised in election petition proceedings. Therefore, I respectfully submit the full court was clearly right to exercise its jurisdiction and to hold that the High Court did not have jurisdiction and to dismiss the application as a consequence. And I may have just exceeded my time, Your Honors, unless there's something like that. Just do it.
Well, there's one last concern that I have, which I must express, and that is the jurisdiction of the full court itself. Submissions indicate that the matter, and of course the fixed date application involved an examination of the powers, some questions under the Constitution, and the powers of GCOM in relation to several of the functions that are complained of, or the omissions that are complained of. And my concern is that in Guyana we have an appellate tier of appeals in the High Court. Are you hearing me? We have an appellate tier, which is the full court. And my concern is whether the nature of what was before the court was in fact a matter that fell within the jurisdiction of the full court. I say that to ask whether it was not the Court of Appeal that was the court to have entertained, or to which that application or the appeal on the jurisdiction should have come. Because Article 133, I think Dr. Alexis mentioned it in his submissions, Article 133 sets out the position that appeals and provides that, among other things, that questions concerning the interpretation of the Constitution are to be decided by the High Court, and that appeals are to the Court of Appeal. So my question is whether the full court, which traditionally has been a court that deals with interlocutory appeals, whether the full court indeed was the court to entertain a matter that, an appeal that concerned constitutional questions, which I believe this was. Although there might be differences as to exactly what those questions were, I believe that all the parties say that there were some constitutional questions involved. So my question is whether the jurisdiction in such matters, in the appeal, which was before the court, the full court, ought really to have been within the purview of the Court of Appeal, and whether the full court in fact had the jurisdiction to make the orders and to adjudicate in the matter. So I raise it because it is a question that I certainly would want to consider. So please tell me if it is a question I ought not to consider. But my understanding of the tier of appeals in this country in relation to questions involving the Constitution is that the High Court in its original jurisdiction hears those questions, and appeals go to the Court of Appeal. So what is your response to that, Mr. Mendez? And my further question is, if indeed the matter ought to have come to the Court of Appeal, what ought to be the position now of the Court of Appeal in relation to what is before it?
Yes. Much obliged. Well, of course, we do address that question in detail in our reply that was filed yesterday. don't have the exact paragraphs numbers, but we do address it there. Now, one thing is that there is no dispute between the parties that the order which Justice Holder made was an interlocutory order, and therefore there was no right of appeal under Section 6.2 of the Court of Appeal Act. And as I think that Your Honor has just pointed out, ordinarily the full court is there to deal with interlocutory appeals. As I said, there is no dispute between the parties that Justice Holder's ruling on the question of jurisdiction was an interlocutory decision.
But you also say that the full court made an order which was final. And so to the extent that the full court made an order which was final in its nature, disposed of the rights of the parties on questions which involve the Constitution and interpretation of the Constitution, although there were many other issues involved in the case, but there was certainly an element of constitutional interpretation. So should you then have gone to the full court, should you not have come to the Court of Appeal, given the provisions of Article 133?
Yes, I understand that, Your Honor. And what I'm saying is that it is agreed that Justice Holder's order is an interlocutory order, not a final order. The question whether the full court's order is a final order is a separate question, because what the full court did was it dismissed the application. And the learned friends relied on a decision of the CCJ, saying that in those circumstances the order is to be treated as a final order. So we're not dealing with the order of the full court. We're dealing with the order of Justice Holder and what was the appropriate route to deal with his order. Article 133, it applies only, it gives a right of appeal only in relation to final decisions of the High Court. And again, applying the reasoning, Justice Holder's decision was not a final decision, and that is agreed upon between the parties. It was an interlocutory decision, for there was no right of appeal to the Court of Appeal by way of 133 of the Constitution. So that is the first point that we make. It's very clear. As a matter of fact, when we had made an application for a stay before Justice Holder, he pointed out that we have to go to the full court because it's an interlocutory order. So everyone operated on the basis that the proper place to go was the full court because it was an interlocutory order. And indeed, no point was taken as to the jurisdiction of the full court either by the learned friends, the appellant. They took no point. They take the point now, but they took no point then, and I think that they were right then. They are wrong now. They are right then because we were dealing with an interlocutory order, not a final order of Justice Holder, and therefore 133 did not apply. It did not apply for the other reasons we also set out in our submissions. But what was being dealt with there was the question of the jurisdiction of the court. The jurisdiction of the court, in particular, having regard to Section 140 of the Representation of People Act, which is legislation, not constitution, so it's not a question of interpretation of the Constitution. And also the provisions which tell you that you must go to the election petition are provisions of the National Assembly of Validity of Elections Act. Section 3 and Rule 3 which say that you must do the questions that are raised under Article 163 of the Constitution are questions that must be pursued by the election petition. He made determinations on those questions as to whether he had jurisdiction. As a matter of fact, when you read his judgment, he makes no determination on the Constitution at all. When you read his judgment, he is speaking entirely about Section 140 of the Constitution, and he says that 140 does not apply, Annis applies, and therefore you can review, he has jurisdiction when you're challenging when you're saying that the Commission had no jurisdiction at all. So when you read his decision, there was no reason to think that we had to appeal a question concerning the interpretation of the Constitution. He didn't address it at all. So for all of those reasons which we set out in our written submissions, Your Honor, this was a matter that had to go to the full court. We had no right of appeal to the Court of Appeal.
So I looked at paragraph 32 of the judgment and paragraph 98. And having come to 32 of the judgment of the full court, and paragraph 98. And I still ask the question whether, given the jurisdiction of the full court in constitutional matters and the nature of the jurisdiction of the High Court in these matters, whether it doesn't really involve the High Court in its original jurisdiction on appeal, and then the appeal would be to the Court of Appeal. And my understanding is that there isn't really a role for the full court in such matters. And as I said, paragraph 32 and paragraph 98 seem to raise issues which suggest that it may have been a matter for the Court of Appeal. That's just my observation as the court. But if you could please help me with that.
Yes, in paragraph 32, the full court says, in the appeal before this court, the singular determination of the question of jurisdiction will decide if the case goes on to a hearing into the substantive issue. In our view, it's amongst an exceptional circumstance permitting the exercise of the discretion to hear this appeal. The ruling made by the OJ is not one that is merely interlocutory, and for the progress of the case as regards, for example, parties to be heard, pleadings or evidence to be led, it speaks a more fundamental issue whether the High Court has jurisdiction to hear the FDA, goes to the root of whether the matter should proceed at all. What I understand the court to be saying there, and she said it earlier, is the full court has jurisdiction. As a matter of fact, she made it clear that this was not a question of the jurisdiction of the full court to hear the matter. It was a question as to whether in its discretion it ought to hear the appeal, rather than... Paragraph 98? Yes, if I may just make the point in relation to what she says, it's not one that is merely interlocutory. She's not saying that it is not interlocutory. In other words, she's saying it is not an interlocutory order like other interlocutory orders, such as whether the parties are to be heard, or what the pleadings should be, or what evidence that should be led. She's saying it's a more fundamental interlocutory order. That is to say, whether the court should proceed to hear the case. And as far as paragraph 98 is concerned, if I may take a look at it, 1 minute, please, Your Honors. She says, without a doubt, the court is the ultimate interpreter of the Constitution. The issue here is not whether the court is prohibited from interpreting the constitutional provisions to assess the constitutional legislative compliance with them by GCOM. It is when and how the question could be asked. Given the special legislative matrix set out above, which governs the elections process in Guyana. Further, it is whether the legislative mechanism provide effective control in the face of complaints such as those made by the case respondent. That is the point that was made by Petri and Kumar, Your Honors, that I was at pains to point out to the court. What she was just examining there was the appellant's case, that what was involved here were violations of the Constitution by GCOM. And she's pointing out that the High Court will have to determine the question of the constitutionality of GCOM's actions at some point in time. But she's pointing out that the question that she has to ask is when it is and how is the High Court to determine those questions. She was not saying that Justice Holder, in his ruling on jurisdiction, was dealing with constitutional issues. She was saying that in the substantive application before the High Court, constitutional issues were raised, but the question is whether those constitutional issues could be raised and must be raised on the election petition. And that is what, as I pointed out, Petri and Kumar decided. But when it comes back down to the question of where do we go to appeal against Justice Holder's decision, that is determined entirely by the nature of the order that he made. It was not a final order, and the appellants agree on that. Not a final order. Justice Holder thought that, and that point is not raised before the full court. If it is not a final order, we can't access the court under Section 133, even if he had interpreted a provision of the Constitution. We could not access it because it is not a final order that he made, as all the parties have agreed. And that you will find that in Madrid for submissions before you, where they are referring to justice holder's decision as an interlocutory order. I'm surprised that they contend otherwise now. The difference between this order and the full court's order, which led to the concession, as it were, that the full court's order was a final order, is that the full court went on to dismiss the application altogether, thereby determining the rights of the parties.
Thank you.
You want to forgive me? Just to be edified and see the submissions. Our submissions are to be found in the initial submissions by Barry Jagdeo from paragraph 10 through to 12, page 2 and 3 of those submissions, where we cite section 133 of the Constitution, which says an appeal to the Court of Appeals shall lie as of right from decisions of the High Court in the following cases, that is to say, final decisions in any civil or criminal proceedings, and final decisions given in the exercise of jurisdiction. So when senior speak to final, we speak to this final in the context of 133, and we also point out that 133.2 exempts all questions that go to the Court of Appeal that deal with provisions under Article 163. And secondly, Your Honor, those submissions are dated April 2nd, 2020. Secondly, Mr. Keith Lowenfield's affidavit, to which Senior referred to, is to be found at page 543 of the record of the full court, which is submitted to this court as part of the record of appeal. And in particular, paragraph 10 and paragraph 15 of that affidavit speak to the process as it pertains to the report. Thank you very much.
Yes, anything else? Mr. Jonas, you wish to be heard?
Thank you very much, Your Honor. I heard Mr. Mendez, and it is difficult to improve on what he has said in terms of distinguishing the matter before you from one which is an interpretation of the Constitution. I did take note of Your Honor's observation, inquiry, whether an appeal from Justice Holder should have gone to the Court of Appeal. I am assuming, and I will respectfully ask the Court to correct me if I'm wrong, that that inquiry is premised on Article 133 of the Constitution, which speaks about appeals in constitutional matters to the Court of Appeal.
It is.
Thank you very much.
As well as when one looks at the original, the first set of John Doe cases, John Doe number 1, where the issue before the court was an interlocutory issue, and that matter went all the way to the Privy Council through the Court of Appeal. And so that was an example of an interlocutory decision that was that was appealed to the Court of Appeal and not to the full court. So that is really, that's my, the nature of my query.
Thank you very much.
As a basis.
Your Honor, of course, the question of interlocutory turns on whether the order terminated the action or not. And in the case before Justice Holder, when the question of his jurisdiction was raised, Justice Holder's order was that he had jurisdiction, and therefore he made an order as to the continuation of his conduct of the matter. By definition, therefore, this was not a gray area as we so often have. This was with both feet in the middle of what was an interlocutory order. Now, Article 133, to which Your Honor refers, is very specific in respect of appeals where constitutional issues are raised. And Your Honor, assuming that this is a constitutional action within the language of Article 133, Mr. Mendes has argued that it is not, and I can't improve on that argument. But Article 133 is very specific. It says final orders go to the Court of Appeal. It makes no reference whatsoever to interlocutory orders. And therefore we are left to fall back on the jurisdiction of the Court of Appeal under Section 6 of the Court of Appeal Act and the jurisdiction of the full court under the provisions of the High Court Act. And my respectful submission is that there cannot be any doubt that given that the order of Mr. Justice Holder was not a final but was an interlocutory order, even if this court disagrees with Mr. Mendes and with the named respondents that it is a constitutional action, even if this court disagrees with that, the fact is that it is an interlocutory order and therefore Article 133 cannot apply. It was an order which did not terminate the matter, but contemplated the continuation of the matter, Justice Holder having decided he had jurisdiction and therefore intending to proceed with the matter. And therefore Article 133 cannot apply. Your Honor, insofar as my friend Mr. Scott has pointed out his view that the full court erred in the exercise of its discretion to hear the appeal because he feels jurisdictional questions are commonplace. Again, Mr. Mendes has addressed that in a way that I do not propose that I can improve on. But I would like to make this observation to Your Honors. Both parties, applicants and respondent, have informed the court of their view that the full court had jurisdiction, and the question was whether it should exercise its discretion to exercise that jurisdiction. It turns on discretion. The full court exercised its discretion by pointing out that given the urgency, and given that the question turned on jurisdiction, it could, if it decided that the court had no jurisdiction, immediately end the litigation so that the process could continue. It treated that as exceptional. Jurisdiction must be exceptional. You cannot close your eyes to jurisdiction to allow the court below to continue. But, Your Honor, as Mr. Mendes has pointed out, given that we are in the realm of the discretion of the full court, it is clear that this appellate court may only interfere with that exercise of discretion, not if it disagrees, but if it believes that discretion was so woefully wrong that no reasonable court could have exercised that discretion. And in that regard, I respectfully acknowledge the observation that you yourself made, Madam Justice Gregory, that there are two factors which you put to the appellant and to counsel for the appellant in his submissions: national importance and urgency. Your Honor, those are absolutely critical. We have spent over 2 weeks in court litigation which has caused delays due to no fault of GCOM. And if the full court found, as it clearly did, and as it said unambiguously, that there is no doubt that there was no jurisdiction in Justice Holder to continue, all the full court could have done was to say, we are putting a stop to this, there's no jurisdiction, application by the lead or dismissed, go back to GCOM who has the jurisdiction. And that is what they quite properly did. And with great respect, Your Honor, the two criteria which you have just identified must manifestly resonate to reject any suggestion that the full court could not possibly have exercised its discretion in favor of hearing the appeal. The final observation I wish to make, please, Your Honor, pertains to the memory of Dr. Alexis. He kindly reminded the court that I had referenced paragraphs 59 and 61 of Keith Lowenfield's affidavit. He omitted to remind the court that I also pointed out section 33 of the affidavit of Mark France and exhibit R to that affidavit. Now, the reason that I raised that, Your Honor, is that The full court made an observation which I think is critical, and which in fact flew in the face of an assertion which was made by Dr. Alexis before that court. The full court concluded, and I think its conclusion is absolutely justified on the face of the evidence, that GCOM decided to do a recount, and its decision was bolstered by information that Messrs. Granger and Jacques had reached an agreement. Now, the word bolstered cannot allow any doubt. One comes before the other. If you take a decision and your decision is bolstered by something, that something happened later on. And if I can refer you, please, to paragraph 73 of the decision of the full court. The full court says the statement of the chairperson of GCOM, as exhibited on the record, is indicative of an attempt by GCOM to fulfill its mandate and to address the difficulties which have clearly arisen regarding the completion of the election process. So there is no suggestion that GCOM wasn't doing anything, and we're talking about omissions and failings. GCOM is acting. And the full court says the public statement indicates an undertaking to facilitate a recount, and that subsequently this undertaking was bolstered by the CARICOM initiative. It is clear from this statement that the CARICOM initiative for a recount was a mechanism to assist with a recount which was already under consideration by the chairperson and the GCOM. Now, Your Honors, I will ask the court respectfully to step back and look at timelines. Friday the 13th was the day that Mr. Mingo did his assessment of polls. If we refer to Exhibit R to Mark Francis' affidavit, you will see that the very next day, that same weekend, GCOM met and decided a recount was necessary. The next day. Ms. Moore's application, quarreling about that decision already made, was filed the following Tuesday. And in the interim, on the affidavit of Lowenfield, he had already received instructions from GCOM, and my learned friend has just cited the paragraph to the court, to deal with the mechanism of how this recount, which had already been decided upon, was to be done. And therefore to put draft orders and send them for advice and that kind of thing. But all of those steps deal with mechanisms to implement the decision already taken by GCOM long before that they're doing a recount. So this talk about failings and omissions and nothing was done flies in the face of the finding of the full court in paragraph 74, and flies in the face of paragraph 33 of the affidavit of Mark France, and Exhibit R, which is the press release that is referenced in that paragraph, and in the affidavit of Lowenfield himself, who deposes to having received instructions from GCOM in the intervening period. I'm very grateful to you.
Your Honor, if I permit me 2 minutes, Your Honor, to offer the court some assistance in relation to the concerns expressed about John Doe.
Mr. Nanda, for the 2 minutes that he's asked for?
Yes. in relation to constitutional reliefs, fundamental rights, etc., by originating motion or originating summons. And that was the issue. It was not whether you could go to the High Court, etc. It was never a big issue about that. It's just what procedure should be used.
I simply raise it to point out that the courts that were engaged on the issue were the High Court, the Court of Appeal, and at that time the Privy Council. I'm not using that case as any authority on the issue of jurisdiction, but simply as an illustration of how the courts became engaged, even though it was not the substantive issue involved in Journal Number 1. I merely, for whatever it is worth, then.
I just wish to emphasize, Your Honor, John Doe dealt, like any case dealing with fundamental rights, it will originate in the High Court, and when it's disposed of in the High Court, it will come to the Court of Appeal. This is quite different.
That is exactly what the Constitution says about matters involving questions of interpretation. So it's not exactly relevant. Well, Mr. Nambla, I get the point. As I said, it is just a concern. I may well agree with your and the other submissions I've heard on the point.
Yes, the court has enough material.
It is a question that is playing on my mind.
Very well, Your Honor. Thank you very much.
Please permit me, Your Honors, I did indicate to the court that I would indicate any information which may be material that I become seized of during the hearing of the matter in relation to my client. I have been instructed that the decision was made to conduct a recount. However, the execution of that decision and the process will not commence before Sunday. So in the circumstances, I believe neither of the combatant parties here will be prejudiced in any form or manner.
Thank you, Ms. Kite. Mr. Ford, is that sufficient? I would think so. Thank you.
Grateful, Your Honors.
Well, thank you very much for your very helpful submissions. Dr. Alexis, Mr. Mendez, Mr. Scotland from out of the country. Thank you for your very quick responses and enlightening.
Please, Your Honors, if I may please, the appellant would be afforded at least 5 minutes to reply to the appellant's case.
We'll allow you 5 minutes, yes.
Much obliged, Your Honor. When my learned senior counsel friend Mr. Mendez was talking about Petrie and Sekumar and Ram and Pete Harry, I could hear him loud and clear. When he got to Hollanda, he went down Soto Voce. It's in his way. The fact of the matter is that there are 2 points here. One, Petrie, Sekumar, when he got to Hollanda, he went down Soto Voce. It's in his way. The fact of the matter is that there are 2 points here. One, Petrie, Seconda, Rambi, Parry, none of those cases paid attention to any provision similar to Article 143(1)(a) of the Constitution of Guyana. None of it. Secondly, fact of the matter is that even on the presentation of my learned senior counsel friend Mr. Mendez, there are already before the court 2 exceptions to the election petition reach. However, the holiday is inferior to more in this context, given the constitutional dimension of most cases. And he graciously reminded the honors that yes, Ventos arose before the election too. So right out of his own mouth, he is showing that there are exceptions to the election petition regime. And that's all we are saying, and that our case is stronger than Holodoc. Mr. Mendez would have your honors believe that the order under section 22 was not proceeded with because of an order made by the court. That is not so. The chairman's submissions, page 10, shows what was prevented by the court order. She states there that the team CARICOM was ready to come into the country, but stopped because of the court order. There was no court order preventing a section 22 order. Thirdly, I am grateful to Mr. Jonas for that, because he is invoking that press release as showing that GCOM had made a decision to have a recount. Of course, the honors just said what Ms. Kite said. What does this press release say? The press release has the chairman saying, I would facilitate the recounting of the ballots, not GCOM. I would facilitate the recounting of the ballots. And in the last paragraph, the chairman said, I welcome this initiative and would assure everyone that GCOM will cooperate fully with the process. That's not a GCOM statement. That's the chairman's statement. Again, Mr. Jonas keeps saying that Lowenthal said he had instructions from GCOM. Well, all we have to do is to look at Lowenthal's affidavit, paragraph 23. He says, pursuant to instruction to facilitate the national recount. He doesn't say that he got those instructions from GCOM. He doesn't say that. So let's not Mr. Jonas write words into that paragraph.
Your Honor, Senior Counsel is referring, I'm very sorry to interrupt him, but he is referring to an exhibit that I have not mentioned. He's referring to a document that I have not cited. I think he would be more helpful to the court if he referred to the document that I cited. I will ask Your Honors for an opportunity to read from the exhibit to which I have referred.
Mr. Jonas, there's an order. So we'll hear you if you wish. Yes. Don't turn
May it please Your Honors. Mr. Jonas referred to a press release just before he referred to Lowenthal. Was it closed? If I'm wrong in referring to this press statement by the chairman, I stand corrected. He didn't say what press release it was. If it's another press release, I stand corrected. But all I'm saying is that this press statement by the chairman does not show at all that GCOM had taken a decision to recount. That's all I'm saying. Now, I agree with Your Honor, respectfully, that Article 133(1)(a) may be relevant. And if there's one thing that could be said about it, is that it militates against interlocutory appeals in constitutional matters. It militates against that. Like Your Honor, Gregory, I too am not pressing anything in that context. But let me just sum up them by saying, my learned senior counsel friend Mendez, after all that he said, had to conclude, yes, there are exceptions. One is Ventos, one is Holodoc, and Holodoc is very strongly in our favor. Our exception is stronger than ours because we are raising questions as to the interpretation of the Constitution. Much obliged, Your Honor.
If I may just correct one thing that my learned friend, Dr. Alexis said, please.
Yes.
He said that none of the authorities cited considered the argument made in relation to Section 130, Article 133 of the Constitution. In fact, Sikumar considered the identical argument, and you will see that at page 47 of the West Indian Report of letter D. That the argument was made in relation to the then Article 92 of the then Constitution, which is equivalent to the Article 133. And it was the very same argument that my friend made in relation to Article 133 and its impact upon the jurisdiction of the High Court was made in Sikumar and rejected. I won't read it, I'm just directing your attention to correct my little friend's statement that none of the cases dealt with it. That's all I'm saying. So direct your attention to page 47, letter C onwards.
Have I got corrected in relation to Petrie and Ram and Peters and Parry? Am I tried to there too?
Okay, Council, we will have to close off the arguments. Yes, Mr. Jonas, 2 minutes.
Thank you very much, Your Honor. Yes, please, not even that. The court will remember that I cited paragraph 33 of the affidavit of Mark France and Exhibit R to which it refers. That exhibit is a press release from Newsroom dated 15th March. Your Honor will see that is the Sunday after the 13th of March. And it says, the Guyana Elections Commission has instructed its Chief Elections Officer to come up with an operational plan dealing how the national recount of votes from the March 2 poll will take place under the supervision of a high-level CARICOM team. After some 3 hours of meeting with the Commission, the CEO, Keith Lowenfield, has until 6 o'clock Sunday to produce this plan. I think that is the article that needs to be referenced. It shows a meeting by GCOM over that weekend immediately following the declaration. It shows instructions given by G to Lowenfield as to how to implement. I'm very grateful to run this.
Thank you for that clarification.
May it please, Your Honor.
No, Mr. You're hearing Mr. Ford.
May it please, Your Honor, before you go, whilst my learned friend Mr. Jonas was referring to press releases, on the record, there are affidavits of Corbyn, Charles Corbyn, Desmond Trotman, and Vincent Alexander. And I believe
Okay, so we move on then, Mr. Ford. Nothing. Well, thank you very much. And as the court indicated earlier, the court will convene on Sunday at 11 a.m. for the decision. Thank you.
You are now able to work from home. $3290. Did you know the FBI warned against using public Wi-Fi? And hackers using public Wi-Fi can download viruses and steal all of your private information. Let Globespan help you protect against hackers by providing you with a virtual private network or VPN. Keep all of your data hidden and protected, including sensitive information, documents, bank account numbers, and more. The FBI recommends using a VPN, and Globespan can help provide one for you. It's very simple and easy to use. Call Globespan today. In Georgetown, call 225-9054. In West Coast, call 269-0141. Or in the United States, call 718-551-3290.